and I really invite this to be a discussion because, and if you do get a chance to read the paper, that I believe Colin had shared the link, but you can find that also. I believe it's there, but anyway, to check that out. And the sort of irony of it was written and researched before the pandemic, and it becomes even more important, obviously, with the pandemic and considering ODR, because many of us really sort of got into the field and became interested simply because of online dispute resolution being a way that you can expand access to justice and how exciting it is. And I remember back in the day, way back, looking at eBay and PayPal and deeply thinking, wow, this is really cool. It's providing people with a remedy where they otherwise would not get one, because I had done my own empirical research way back when, before the drive-through arbitration article, just looking specifically at the squeaky wheel system, and also looking at when and how consumers get remedies, and often, of course, consumers go away with nothing. And so that is why technology really opens doors, but it also can close doors. And we're at a point where we really have to think deeply about technology, and are we fitting the form to the fuss, and ways that we can expand access to justice. And a lot of this, you all know, especially considering you're part of Icodr, is, you know, the different ways that we really look at ODR and online dispute resolution. It can be problem diagnosis and wizards, different guided pathways toward remedies, of course, online negotiation, online mediation, and online evaluation, which in most cases is OARB, online arbitration. And this is all, again, just review. Let's just really think about sort of the functional analysis. I'm a big functional analysis proponent, meaning let's look at what is the problem we're trying to solve. In fact, I teach a class called Lawyering and Problem Solving to 1Ls at University of Missouri. It's required. And because I think it's really important for attorneys when their first day to think about being an attorney as a problem solver, not a problem creator. And so we want to look at the reasons for ODR. We want to think of why it was even developed, and why those of us who are passionate about ODR, why we think it's actually really helpful. So first of all, if I can just pause for 1 minute here.
No worries. I was looking for who I needed to mute to make that sound go away, and that, unfortunately, it was Amy, and I can't mute her. So I'm going to mute everybody, and then she can unmute. Amy, I'm going to mute everybody, and then you can unmute. So unmute again. Sorry.
Sorry, is it now? Okay.
Now we're good. We're good. Thank you.
Okay, I was hearing some background. I just wanted to be sure nothing weird was. Okay, so anyway, I'm getting back to sort of the functional analysis and why ODR even is helpful for expanding access to justice, not simply efficiency. Of course, efficiency is also a benefit of ODR, but fairness and expansion of fairness really needs to be top of mind, because that is what is going to help it to succeed. And I remember Colin and I even talked about this with the new handshake. The idea is, if you create a system that's very fair and that helps to expand access to justice, you're building the field of dreams, and then they will come, right? then you get traction, you have scale, because individuals are looking for it as a way to expand access to justice. And so again, litigation and face-to-face are costly, cost money. Consumers want mobile access. That is absolutely true. So mobile-friendly dispute resolution. Also, the ability to use data analytics and online neutrals to help assist resolution. There's also sort of the hassle, travel, and time off of work involved with face-to-face. ODR is able to adapt to different language, education, physical, and time differences. Also, government programs have really been aimed to cut costs. For example, with Her Majesty's Online Court, I feel blessed that I was invited to be at one of their sort of early research meetings in discussing sort of what Her Majesty's Online Courts would look like. And of course, austerity and saving money was really important, but yet the Legal Education Foundation and others wanted to be sure that access to justice was also considered. Again, online wizards and chatbots have become really exciting for empowering self-represented litigants. Huge growth in that area, exciting things happening. Also, really, the space of computer-mediated communication can ease the stress and fear of face-to-face interaction. I remember, and this is way back in like 2001, 2002, I was doing some focus group research and discussing sort of different face-to-face dispute resolution mechanisms with individuals where it was kind of a random group of people. And there's a lot of fear and stress about walking into a courthouse or even having to walk into a boardroom or any kind of a face-to-face arbitration. So really easing the stress to allow for somebody to resolve their disputes from their home in their pajamas, as we were talking about in the beginning. The evolution, I think, again, a lot of this is history that you all know. So I'm going to go through this really quickly. Some of the early programs, obviously eBay and Colin's work, and also Matterhorn has been around for quite a while in doing works in the court. We have eBay, Amazon, Alibaba, you've got Modria, Tyler, Matterhorn, TurboCourt, all entering different e-courts and ODR pilots. I have an article that came out last year. Welcome to check that out, which talks specifically about e-courts and sort of going into the different projects and some empirical data I was able to look at, especially out of Ohio. Now here's where we want to stop and sort of think, and this is new, right? This is not even in my article. I obtained this from the ABA, the American Bar Association Center for Innovation, came out with these charts. And I just wanted you to kind of look at sort of this exponential growth. And what's interesting about this slide is this is up until 2019. So mind you, this expansion of ODR in the courts especially has really grown by leaps and bounds even before the pandemic hit, right? I would argue that this number is probably double now that we've entered and are in 2020. Also looking at, again, and this is only data through 2019. And again, this is only looking at ODR in the courts. And the reason I'm focusing in this discussion on court ODR is because courts have a special duty with respect to due process and access to justice, right? Courts, they are a public entity. It's part of our democracy. This is important for a lot of different reasons that really go beyond even, talking about a private dispute resolution process, such as we see with an Amazon or an eBay or a PayPal. So again, you can see where there's exponential growth. For example, Michigan, that's not a surprise because Michigan is where Matterhorn is based, right? And so we see a lot of this kind of growth in places where you have companies that are strongly aligned with the courts, right? But this is just the tip of the iceberg. Again, this is only through 2019. And of course, we know outside the US, there's even more happening. I mean, the CRT, Parlay, Cyber Justice, and more in Canada. I would argue that Canada, in terms of per capita, is ahead of everyone else in terms of ODR in the courts. China, of course, has the Hangzhou Internet Court. There's some concern about where it's located and who tends to win, but nonetheless, it's there. You have the UK with Her Majesty's Online Court, which I mentioned earlier, and of course the EU, the platform with the ODR regulation. There is some question there in terms of whether it has gained sufficient traction in all of the member states. Certainly you should look at the data, and the EU keeps pretty good data on that. And there are certain member states who are utilizing that platform with greater facility. CRT, now this is important because it kind of gets more into this fitting the form to the fuss and into sort of what I'm hoping we can discuss more fully is, again, adapting and doing research and adapting, research and revise, research and revise. I say the 3 R's, research, revise, and repeat, meaning do research about the project, right? When one of the beauties, one of the exciting things, why does Pew Charitable Trust have a court modernization project that looks at ODR? Because what's awesome, my friends, is that technology is nimble, right? And so it's more flexible. The, older male judge in the dark robe with like a wig or whatever, that's less. Traditional court processes don't move very quickly, right? I can make all the phone calls in the world, but that doesn't mean that courts in Missouri are likely to quickly adapt and quickly bring in online processes or to really change very quickly. The rules of civil procedure do not change very quickly. However, in contrast, if you have an online dispute resolution program, you can actually do research, find out what's working and what is not working, and then revise accordingly, which is precisely what functional analysis. Look at the function. What are you trying to achieve? What are your goals? Create a process to do that. Test the process. See if things aren't working. Revise accordingly. This is one area where the CRT has actually been working to that extent. Now, I would argue that they could do deeper research, because if you really look at the responses, for example, 50 responses to the satisfaction survey in May, that's really not very many. So you'd want to get deeper and broader research, but nonetheless, at least shows a strategy aimed toward that research, revise, and repeat. I also, again, thinking about functional analysis, invite you to think about contextual dispute resolution, because again, the fuss, the context is different in different cases. Small claims, tax appeals, traffic tickets, family, condo, landlord, tenant, they have different needs, right? And so we really have to think about that context. Now, again, going deeper into what do we have from the court innovation visual report is it shows us the areas that are growing most quickly, right? And it's not a huge surprise that traffic is one of them, warrants another, civil debt is actually growing. Small claims, I would argue, is growing by much larger percentage now after the pandemic hit. Seeing more growth into landlord tenant and debt, which are sometimes controversial, but I think it's worth it to see the different contexts where ODR is starting to really take off. Okay, so we know this is happening, right? It is what it is. It's not going to go backwards. The genie is out of the bottle. I would argue that we're just going to see more technology in the courts, out of the courts. OR, for example, is here to stay. I don't think we're going to go back to as much of the face-to-face traditional processes. But we have to stop and ask, is ODR fair, and why do we care? Well, again, if the reason for ODR, one of the main reasons, not the only, is to try to expand access to justice, then we ought to think about really what is access to justice, right? And so I went and looked, and one of the main access to justice indices is Fordham University has put this out, and they have a project. And really, justice depends on having a fair chance to be heard, regardless of who you are, where you live, and how much money you have. I mean, that's important. At a minimum, a person should be able to learn about her rights and then give effective voice in a neutral and non-discriminatory formal or informal process, right? And applying the rule of law and enforcing the result. So there are a couple things we want to be thinking about as we assess and do research with respect to ODR. So we think about these features, okay, and we think about what is fair and why we care. Well, now this is where I want to get some audience participation, because, okay, so going up until this is again data through 2019, so we don't have the 2020 data, but this is interesting. We're looking at the different features of ODR. These are court ODR systems currently abound. Does anything look problematic to you in light of what we think is access to justice, or in light of some of the principles that we hold dear? What do you all think? I want to get some other voices. Anyone see anything that kind of makes them go, maybe this is an issue we should be addressing as the ODR community, something we might worry about because we want to promote access to justice?
Accessibility.
Right, the non-English.
Okay, let's go. And I think, where did I hear accessibility first?
That was Laura Castor.
Oh, thank you, Laura. So why? Where do you see it, and why do you see that as important?
Well, I see it as a problem in terms of the chart, but I also think it's generally a problem. I mean, we have all these school children, for example, currently taking online courses without access to online internet or maybe a tool. And it's, I saw some statistics somewhere that only 40% of the kids who are supposed to be online in at least one school system have ever signed in. So I think that, I think this whole idea of apps and access through computers is wonderful, but how are you going to make the computers and the internet actually accessible to the people who you're serving?
100%. I mean, that's so important. And the thing is, when you see 71% unknown, only 24% actually can say yes, accessible for people with disabilities. That should really raise our red flag and think, okay, as a system, designers and as people who care about online dispute resolution, we ought to really sort of take a pause and be creative and think about ways that we can address that problem. Again, ODR being nimble, there are ways we could probably address these issues, right? I also heard, I'm sorry, who again called out the non-English language access?
Yeah. Yeah, the fact that we don't know is really scary.
Right, right. I like
Yeah.
that. Perfect. Yes, absolutely. I mean, think about how many individuals, and again, and the reason I even had you kind of go through the journey of looking at the context, it's very important, right? Because a lot of these small claims, a lot of the debt collection, a lot of landlord and tenant, especially during a pandemic, right? Well, of course, that was through 2019, but still, you were talking about a lot of non-English language speakers, and how are they going to access these systems, right? And so it does become very important, especially when it's a presumption that you will be part of the program and you have to actively opt out, which is generally the norm in a lot of the different systems that are being developed. And of course, I understand the arguments. The argument is, well, hey, if I, as a court, if I'm going to spend the time and money in establishing an ODR process, I want people to try it. And if I have it as purely optional and not a presumptive opt-in, well, then are people going to really try it? But then that requires that the consumer or individual proactively opts out of the process. Well, that can sometimes require a lot of the individual. So it's something to think about when we are worried about system design and access to justice. What other issues jump out at you? Are there any other things when we look at these features of systems that are lacking or are questionable?
May I add a comment, Amy? This is Mirez speaking.
Oh, yes, Mirez, please go ahead.
All right. I like very much the comment that you made, because it's true that when a system has been designed, you want obviously the users to use it. But how do we get to users? We need to educate them. We need to bring the information to them. How do we do that? First, we can count on the administration. So on any social administration, of any kind of assistance to users, on getting the information really available, even to those who are non-English speaking people, and to any sort of people. Like no user will go to internet and know that it can solve potentially a dispute online if it is not fully informed about the existence first. And second, if whoever builds it and makes it available does not report about successful cases, the number of users, how this is solved, and call on other potential users, people will not trust it. You need to make it so transparent and so available that it really enhances the use of resolving technology directly online for any type of person, and particularly those who can never access justice to get remedy for their problem.
Beautiful. I love that so much. I agree. So I'm like jumping up and down. I agree so much, because actually another sort of piece to this talk is, after I wrote this article, I did a shorter project with Heather Culp in New Hampshire, who is a court administrator with an ADR program. And we did a non-scientific where we surveyed different real users, real people. And the reason it even came to my mind was because I thought to myself, what would my mom do, or what would my family do? And I have individuals in my family who don't use the internet all the time, or might not trust it, might not have great access. And so really, you need to make sure to ask these individuals. And when we ask them questions, it was precisely this: they need to have information about the process to build trust in the process, and have helpers who are available. This is another really important issue for court ODR, is that they have essentially assistance available to help individuals if they run into technical issues. Mm-hmm. Great, really.
Amy, I just have a really stupid question. I'm working with the court system in New York on their new mediation programs, which are trying to move a lot of disputes onto platforms. They don't even have the email address of the disputants. You know, if that's not gathered in connection with the filing of a claim or complaint, or if the claimant doesn't have access to that for the defendant, there's an immediate problem. Does everybody have email? We think everybody has email. I don't know about that.
No, you know what though? That's a fantastic issue. Not everybody does, and not everybody checks email. I have friends that don't. They text, but they don't check email at all. So then maybe you need to establish a system where you can text individuals as well in order to provide inroads, because there's no question the research does bear out that, especially if you want to look at the digital divide, a divide still does exist in terms of those that only access the internet with a mobile device. And so they may not check email, or you may not have an email. That is a great point, Laura. And also I know my friend David Larson has been working on that project in New York and is a great resource there as well. I don't know if you've run into him, but he's definitely been kind of front and center working on that project. So I invite you to talk with him. But these are super important issues. I mean, yes, that's great that 77% can upload documents, right? And that 79% they have an electronic document management. But don't we want ODR to be more meaningful and to provide more robust access to justice or access to remedies than simply case management? I mean, it's got to be more than that, right? I mean, that's really the hope and the goal. And so continuing research, continuing to look deeply, to look under the hood, and so that we research, revise, and repeat in order to promote access to justice, I think will really help ODR as a field. It'll help us all, right? And these are really important questions. And so when I think about, well, how should we approach this, right? It's kind of overwhelming. I mean, there's so many different little problems we hear about, or, someone can post a blog where they're, upset about this or that or the other thing. But I want us to really sort of think, okay, how should we approach this? And we do know there are some developments currently ongoing right now. We know that Pew and the National Center for State Courts, they had an RFP, and it did focus on different questions, centrally on whether and how ODR can make a difference. We know they selected 5 pilot court sites, and that there is research ongoing with 3 grant recipients. They will conduct process evaluations on a sample. I know this is currently ongoing, and hopefully it won't be that long, and we will see some results of the research that has been going on. But that doesn't mean that should be the only research, right? I guess I feel that's just that's again, the tip of the iceberg. The beauty and excitement is the fact that there's a lot of other ways that individuals and courts in particular, and researchers like myself and others should really think about this and ask ourselves, okay, I'm always like, keep it simple. Stupid is sort of, I like to keep things very sort of straightforward. So I'm looking at who, how, and what. Who does ODR actually open access to justice without representation, or those who face other resource, language, ability, education, or physical barriers? To the point that Merez made, I think it's super important to design systems that help those with the lowest access, or those that face the most challenges, those that are most vulnerable, right? Especially if we want ODR to make a difference and to expand access to justice. So we need research that considers who's using it, who is not using it, right? And why, right? So how do ODR users perceive the process as fair and feel it works well? Is it user-centric? Real-time user experience testing is super helpful in this way. I talked to some different researchers at University of Missouri, and they have different apps that they have developed where it's possible to actually do real-time user experience when somebody is actually in the process of using the ODR program, so that they can actually say, this doesn't work, this does work in real time. Because we do know, and I'll tell you based on even my own survey research, when you ask somebody about an experience after the fact, you don't get the same sort of real-time accurate answers, okay? Because sometimes the answer after the fact might really depend on whether they won or lost, right? And so real-time user experience testing is actually more accurate and helpful, especially when you want to adjust and revise based on research. Also, the dropout rates. And this is actually something you can gather empirically very easily to figure out when and if individuals are dropping out of a process. do they start the process and file a claim, but then give up because it's frustrating, because there's something they don't like about the process? You can actually catch that on the back end, and that can be quite informative to find out where there might be glitches in the system. And then finally, what? And this one is actually a little bit controversial because different individuals disagree on how and whether this is important. But do ODR users get fair or different remedies than they would obtain through a court or other face-to-face process? Now, in this actually, people disagree, because I think it is important when we think about system design and we think about research and we think about, you should do a compared to what, right? And so you can't say, well, was the outcome in the ODR process, maybe this consumer obtained less money than they would have obtained if they went to trial. Sounds good in theory, but here's the problem. Very, very, very few consumers will actually go to trial on anything, okay? Because most consumers actually just lump it and do nothing. So you have to be really nuanced in trying to figure out other ways you could gather evidence about what sort of remedies consumers obtain. And there might be other ways, different complaint processes, FTC filing complaints, Consumer Financial Protection Bureau filings, because these kind of more informal, semi-formal processes are actually what a lot of consumers use. So you really need to think about compared to what. So it can't just be court, but other face-to-face processes, or even other processes more broadly. But we have to really kind of dig deeper and be creative as we gather that evidence. Because the hope, again, is that ODR provides a mean, for example, for a consumer to obtain a remedy where they otherwise might not have been able to obtain a remedy because of court costs, because of hiring an attorney, because of travel, because of intimidation, whatever it might be. But again, looking at these questions of who, how, and what can help us think really deeply about system design and how we can create a better mousetrap. And this also, of course, goes to the ethics, transparency, and best practices, which are also tremendously important, as Mirez noted, with transparency and really crafting user testing in order to really uncover what works and doesn't work. Also, quality and privacy protocols, having those in place, as well as transparency and publication of results to the greatest extent possible. Now, this one also is controversial because, quote unquote, transparency actually can conflict with the principle of confidentiality and privacy, right? And so we have to think through very deeply how that works. How do you provide sufficient transparency about a process and the awards that are obtained without violating other ethical principles that we care deeply about? And so these are some of the thorny questions actually that the ODR task force, I'm the co-chair of the task force for the American Bar Association, and some of these questions and trade-offs, and also Icodr and the fantastic work done by Professor Leah Wing, who has really been at the forefront of ethics, and fighting and really sort of discussing these thorny issues when you have competing ethical duties. But thinking about both, because these are important, and really qualitative as well as quantitative studies. I'm always a huge fan of both qualitative and quantitative in order to obtain the best picture of what is happening. And finally, engaging and crafting technologies to enhance access to justice overall, because again, what is one of the biggest benefits about technology? It's nimble. And the fact that it's nimble means that we are able to actually research, revise, and repeat until we get it right. Again, I invite you to go. I'm sure you all know because this is an Icodr call, but do please go to icodr.org and look at these ethical standards. We're in fact building on these standards as we talk about the work of the ODR task force and are partnering with Icodr, and many of us are actually working on both the Icodr standards project as well as the ABA project. I thought I saw Dan Rainey, who has also been fantastic in co-chairing one of the working groups for this process that we are engaged in. And I'm hopeful that we will have something out by some point in 2021, that will really be helpful to the community as we think about these ethical standards and really best practices. We haven't decided exactly what we're going to call it, but in more particularity to go even further with specifics beyond standards. Again, some of the key issues we care about: accessibility, accountability, competent, confidential, equal. I welcome you to please go to the website. I won't read these through because I know you know these things. Fair and impartial, legal. This becomes very important, especially with OARB. OARB, as opposed to other ODR, results in a final and binding award. So you have to be very careful in thinking about the process to be sure that the award obtained will be enforceable. This makes OARB and issues around OARB particularly thorny and important for us to think through. Secure, we know secure, that has become one of the biggest and most important questions. Even I, as a professor and using Zoom, right, and using Canvas and using all these online means, there's all these questions about FERPA and how are we guarding student, how are we properly guarding student information. Security, huge question for online dispute resolution. And again, as I said earlier, this question of transparency and how that may compete with questions around confidentiality. Again, it's not simple, but I think we're all creative individuals. And I mean, that's why we're drawn to dispute resolution. Why do we even become involved in this field? Because it's an opportunity to be creative. That's what's exciting. That's why I even care about this stuff. Why I will work all night on these different issues, because I just think it's super exciting to think how we can work together as a community, right? To expand access to justice, to be creative, and to continually evolve and not get stuck in the old ways, like the old rules of civil procedure. I remember as a young associate at a law firm doing discovery and answering interrogatories and thinking to myself, there's got to be a better way. There's just got to be a better way. So at any rate, I want to open it up. I know there are dangers to digitizing due process. And as much as I'm a proponent of online dispute resolution, I'm also a critic. I'll look for ways. I'll look at things that I think are broken and we need to fix, right? And that's where research really becomes important, so we can expand access to justice for the most vulnerable individuals. Again, the article, this was written before the pandemic, so it nonetheless, I think, is relevant after we are now using technology to a greater extent. So I'm going to go ahead and stop well, I guess the last, if you want to reach me, you all know my website and my email, schmitzaj@missouri.edu. But I'm going to stop share and kind of open it up so we can sort of talk a little bit more about things that you all have seen or are thinking about in terms of projects, maybe in your own states, questions you've run across in terms of judicial processes where you've seen glitches, and then to really think creatively, what are some ways to address those problems?
Yeah,
You know,
Meyer has,
example,
I'm sorry, Amy, please finish.
Oh no, please go ahead.
Well, I was going to say Meyer's had his hand up for a while, so I just
Oh,
wanted to
my
give him a chance
apologies.
to
I
ask
did
his
not
question.
see
No,
it.
it's no worries, no worries. You were presenting, and then Katerina, you're next. Meyer,
Okay,
please.
thank you. Can you hear me?
We can.
Yeah, oh, good. Okay. Very interesting talk. You're precisely in our doing exactly what we are trying to do in this nonprofit that we created 7 years ago called the Mediation Center of Los Angeles. Our purpose was to have low cost or affordable, no cost mediations to the public. We were fortunate to be one of two organizations to get a contract with the LA Superior Court. As you probably have heard, the LA Superior Court had a very robust mediation program face-to-face before budget cuts. They then terminated that massive program and now outsourced it to organizations that qualified. We were one of the qualified organizations, and we got a contract also, and the only one, to do ODR. And you raise a good question. How do we have a greater capacity than the cases that are coming in, because it's hard to reach the public to let them know that they could have something online that's safe, secure, ethical, gives them a voice, gets the cases resolved. All the things that you talked about, we're trying to reach out to the public. And we also, we've been getting some interesting cases and getting them resolved with, also, we have to report to the court about the outcome of our cases and so forth. So all the issues that you raised are in our program. And I was just wondering, is anybody looking at the Los Angeles Superior Court program of outsourcing ODR, and it's online court systems now. It's the largest court system, integrated court system in the world. There's 650 courts and 550 judges. So it's something worth looking at, and we're at the middle of it doing the ODR program.
Yeah, I really hope somebody is. I wonder, they should be, and most definitely do. Yeah, because that is really exciting. I'm thinking back, I actually taught an online dispute resolution class at Pepperdine 2 summers ago. And I remember hearing about this while I was out there. And I hope somebody is. I mean, I wonder if National Center for State Courts has been in touch with anyone in your program, because it seems to me that that would make a lot of sense. I don't know if you've talked to Paul Embley or any of those folks.
Could I get information from that?
100%. Yep. Email me and I can do.
Sure, I can do that too,
Colin,
Meyer.
yeah.
The other thing I'll say is, the Pew Charitable Trusts have announced 3 research teams that are doing longitudinal empirical research on court-connected ODR. Correct me if I'm wrong, Amy. One's at Arizona, one's at Harvard, and one I think is at UC Davis. I think they're based. Yeah. Yep. And they're getting money from Pew to do, because a lot of the ODR studies, that we do or academics do, we'll go and we'll get a data set, we'll analyze it, we'll run some surveys, but these are empirical longitudinal studies. So because they want to see what's the impact of these online processes on cases 2 or 3 or 4 years down the road. So I think that this data is going to be really helpful in understanding. And I think Modria is being used within the court for some of their family flows and things like that. I'm very interested, and I'm not connected to that anymore now that I've left Tyler. I'm curious to hear about the relationship between your program and the court's own ODR initiatives, Meyer. But as you said, Los Angeles is huge. It is a massive, massive court system. And sometimes I find that the right hand doesn't know what the left hand is doing, because it's just the scale of the courts is so enormous down there.
Right. Well, and Colin's right. Some of these longitudinal, I mean, they're even doing sort of almost placebo type comparisons. And there's a lot of deep research. I know there's a bit of a pause, unfortunately, because of COVID. There's been difficulty for the researchers to actually get in there and physically go do some of the different interviewing that they hope to do. But I do believe that we will start to see some results. But also, I really think sort of these other looking to other groups, right? I mean, there might be individuals out there in LA, for example, with Pepperdine who are interested in doing that research. And so I think making sure to let it be known that you're gathering that data is really important, because I know a lot of different professors who would love to get their hands on data. So, I think making it known and reaching out to those folks could also be really helpful, because it sounds to me like this is really exciting work that you're doing. I love that. Thank you so much, Meyer.
You're welcome. Thank you.
Katerina, I see you've got your hand up. Do you want to go next?
Yeah, thank you. So we talked about accessibility barriers earlier, based on maybe language and disabilities, but we didn't really talk about age. And as an LDA mediator, I'm really concerned at this point due to the pandemic. I think most, at least halfway educated seniors have a computer, they have Zoom on it, they have email on it, but they don't know usually how to use it without some hand holding from an adult child or some other caregiver. So now you have the person who has the greatest influence in that person's life anyway, hold their hand during legal processes. I'm really concerned about undue influence and confidentiality, because I know sometimes they're sitting in the background because they set up that Zoom. They're not supposed to be there, but how do I know? So I think there would have to be some real-time, not just written chat support, but voice hand holding.
Oh, Katerina, thank you. So there's an article I wrote in 2018. There's an app for that. And one of the things that is absolutely true is age. Age is the biggest issue, and we have to think about this. And your point is so important, because you're right. What if the person you need sort of help to get away from is the one sort of taking care of your access to any sort of a remedy, right? In terms of who's in the room. And I think, and that's where the article I did with Heather Culp, when we looked at sort of real users, we did focus on age actually. And that's why I even called it Ask My Mom, because she's older. And I wanted to sort of think about it from that standpoint. And that's where the idea of helpers and having helpers available for real time, you know, not just a chat, not a bot, but an actual real person. And one idea that I had thought about also is that senior centers having kiosks or having helpers available to help individuals through these different processes. I think that could be really impactful. And also, again, thinking about how, because there's a broader issue that comes on play when you think about online dispute resolution programs coming into the courts, is there's a concern of many of the clerks and individuals who work in the courts that suddenly they're going to lose their job, right? Or there could be issues. And so sometimes it can actually be really helpful to maybe allow for those individuals to be repurposed and to learn maybe to be helpers or to be technicians who can assist in real time as users are going through the process. So it's not as though you lose your job, you actually just transition to a different use that can be more helpful to different individuals. But your point, Katerina, is so important. And I love the depth of the analysis and thinking about the individual who might be the powerful person in your life who you actually need to get some help from, right? And so I think those are some really, really important points.
Yeah, I would say that's also a concern from the family side. You know, when you have people going into the courthouse, you can't really, once they're there, you have direct access to them. But if they're using technology as a means to communicate, there may be people that have control over that technology. And, you know, so I think that's true on the elder side, Katerina, as you note, but I think this is something we need to think about. Another thing that's come up in the chat, Brian talked about, and Chris, I think, echoed this too, that he said, when doing online mediation in Oregon, I found that parties' marginal internet connectivity, usually rural parties, has a severe effect on the conversation itself. And I know you talked about the Icodr standards where we talk about accessibility. You know, as we promote this as a means to A to J, what do we think about some of those? It can be bandwidth, it could be computer quality. There's lots of other issues, you know, that become a factor in A to J. So do you want to address that?
Me or somebody else?
You. I was thinking, just to react to it.
So yeah, no, I was updating, there's a different article I'm working on for a European journal, and I was looking at this question of internet connectivity, because it's really, it's been highlighted, okay? And the funny part, it's really because of education. And what I'm saying is there's a lot of kids who are not able to access school because of lack of internet and connectivity, especially in rural areas. And this is a real concern. For example, here in Missouri, sometimes, and Colin gets actually super frustrated because my internet is sometimes really horrible. And it can be really hard because that means it's a difference between a child being able to access any sort of education. I know Katerina mentioned this earlier as well. And these are real issues that we need to think about. And so, I mean, I think what we are learning during the pandemic is that access to the internet is actually fundamental, right? It's fundamental for a lot of different reasons. And so I think as a community, we have to really think about how we can help with that access to the internet as being really important when it comes to access to a lot of things, not just justice, but education, to the assistance that you need. And so I think that is just sort of raised really the highlight on the importance of access to decent internet.
Do you know of any groups right now that are, let's say somebody does have a mediation coming up where they know that they need strong internet? Are courthouses, for instance, doing a hotspot in the parking lot? Because you can't go into a library, you can't go into all of the traditional places that you used to be able to go to have a good, strong internet connection. So I've been thinking about that. Like, where would somebody go if they know that they need an hour or two to dedicated private bandwidth?
Oh, that's such a fantastic question, Claire. Yeah, I mean, the truth is, sadly, because I've talked to some different individuals, especially on the education front, and there are some people that are literally sitting in McDonald's parking lots to get access, which is really sad, but it's happening. And I think there's movement though in some states. I know I just talked to somebody actually earlier this week in Utah, where they have a lot of issues with internet connectivity in different rural locations. And what they've been doing are setting up hotspots in different
Good.
areas and using kind of these vans essentially and bringing internet to the people, especially to help with children being able to go to class. And so I think you see the same and creating these hotspots as being a vital community resource. And I do know that that is something being considered, especially in more rural areas.
Great, thank you.
Yeah, I think that idea of having like a parking lot outside the court, you know, with Wi-Fi access, I think it's an intriguing idea. I mean, I know that the State Department during the Obama years was talking about access to the internet as a human right. I think we may get to that point very soon.
I agree with that. I mean, it kind of reminds me as a kid. So I grew up in rural, middle of nowhere, Wisconsin. We didn't even have like a library in our town. So then the bookmobile would come. I don't know if any of you ever remember the bookmobile, but I remember.
I do. I loved it.
Loved it because I was a super nerd, right? So I'd be like out on the curb, like super excited. It was like my drug dealer bringing me some books. And I could see though, you could, you know, repurpose a lot of these different vans and things like that and sort of have these hotspots. But I do believe that that is absolutely something we're going to see more and more of. And I think there's CARES Act funding even being used for it in certain places, including here in Missouri, because of this realization that access to the internet is really, really fundamental for a lot of things.
Yeah, most kids, they get excited when they hear the ice cream truck coming. But Amy, she was like running out of the house when the bookmobile is coming down the street. Please, please, give me some civil code. Okay, any other comments, questions, reactions?
Internet is also, Colin, sorry, this is Mireille, is also
Please.
in the IDA. I'm trying to find the exact title. I know I spoke about it in one of my articles. So it's not only a say, it has been also recognized as being a fundamental right.
Absolutely.
Yep.
I think we talked about, like, there was a time when the telephone just became you know, omnipresent, and the government would actually pay to go run telephone lines to rural people, even though there wasn't a financial reason to do it. It wasn't, you know, financially rewarding for the private companies to do it. I think that we may get to that point with the internet too. And I think, Amy, you're right, like telehealth, schools, and we have such dependency on these networks now, especially in the wake of the pandemic. I think the government is going to say this is a good use of public funds to ensure we have 100% access.
Yeah, absolutely. I mean, in a lot of these rural areas, you know, we would have like these shared telephone lines because nobody could really afford one. So then they would run a shared line and families would like share a line. I could see these kind of shared internet sources happening in different places as well.
Yeah. You know, there's a couple people mentioned the great program that Roger and Ismail, who are on the call, are doing with Conflict Intervention Service, doing this kind of on-demand, online assisted mediation of landlord-tenant cases. You know, we've been working hard with Mediation Express to try and mediate some of these landlord-tenant cases because we know there's going to be a big rush, particularly when the moratorium ends. I wondered if you could just talk about that for a minute. I mean, I think that this is a huge access to justice crisis that's barreling down the pike to us. I mean, we found we wanted to put this out there and say, hey, anyone that needs these services, come get it. But it actually was hard to get access to the disputants. I mean, we reached out to legal service organizations, and, you know, what I worry about is we're going to build, you said, you know, field of dreams. If you build it, they will come. I don't know if that's necessarily true. Yeah. You can build and have great mediators and a great service and well-designed, but unless you can find the people that need it, they don't know about it. And that's another challenge. So maybe you could address that a little bit.
Me, or is that toward?
I keep throwing this to you, but I guess anybody can open it up.
No, because I actually have thoughts on it for sure. So Linda Warren-Seeley and I, well, this is like 6 years ago, we wanted to add an ODR component to ABA Free Legal. And so the idea was that you would add a way for people to get their disputes resolved through mediation, mainly. Through the ABA Free Legal, because that is something where people do access it. I think finding those kinds of portals and opportunities, we didn't end up getting the grant funding, and it's still in our field of dreams, but I think finding these different portals that are already attracting individuals who need help, legal aid, there's movements toward how can you incorporate more ODR with legal aid programs. So in different areas where individuals are likely to go to look for help, another sort of field of dreams. I know, Colin, you and I have talked about this before, but what if the CFPB's complaint portal actually led you to an ODR program so that you not only can complain, but you can actually go toward a resolution? Sadly, that has not happened, but maybe in the next administration, that's something that could be on the table, right? And so I think thinking creatively about where do consumers go when they have problems, and then you meet them where they are with problems, right? Where do we find them? We find them filing complaints with the FTC, with the CFPB, going to their legal aid, going to the BBB, Better Business Bureau. Those are where a lot of consumers go when they look for a remedy. They don't go to the courts. There's tons of research to back that up. So I think trying to find those spaces and places where consumers with problems go, and then provide something more than simply somewhere to complain. That would be my advice.
I'll just say too, if you look at the companies that have really tried to reach out and provide direct to consumer support, almost none of them use the language of dispute resolution or the law. You see like Fair Shake or People Claim or Square Trade. It's all about fairness. It's about fair dealing. I think the branding that resonates with consumers is quite a bit different.
Yeah, I think the words like complain and concern is what you do want to look for, in terms of that kind of, that's where I think you're likely to really make a difference and help individuals, because that's what they really want to do.
Mm-hmm. Other thoughts or questions for Amy? I definitely have a lot more that I want to talk to you about, but we're running out of time.
What town in Wisconsin did you grow up in?
Oh, so I was born in Racine, but then I lived in Grand Chute. So Grand Chute is outside of Appleton. So the nearest, so I really grew up, I would say mainly, I was born in Racine, but then really spent most of my sort of growing up time in Grand Chute outside of Appleton.
I spent a lot of time on the river there.
Fox River.
In a tube. Yeah, having a lot of fun.
Oh my gosh, that's fantastic. Yes, that was, total. In fact, my parents currently live in unincorporated Winnebago County, which you might be aware of as well.
So you're cheeseheads. Okay, we've established that. Yeah.
Yes.
Amy, I've been wondering, this is not quite on the topic of access to justice. I just haven't seen this study anywhere, and I'm wondering if you have any familiarity with it. You remember in the book, Thinking Fast and Slow, how it talked about that sentences, that judges would give much harsher sentences right before lunchtime because they're tired and cranky and they'd been stuck in one spot and they couldn't get a snack, and that was reflected on the judgments. I'm wondering, have we seen any changes with that as people are online? Have there been any studies about people are at home and they're more relaxed and they can't go get a snack? Is there a change in in arbitration outcomes or anything?
Yeah, not particular, but one piece though, I do think that is concerning that I talk about in the article, is there was a research study done in the UK regarding asylum, and those that had their hearings done remotely were less likely to be granted asylum because there was more empathy provided in an in-person hearing. And so that was concerning, especially when you're thinking about asylum cases or any criminal cases online. And there's a lot of interest in moving criminal cases online. So it is happening. I've just been, I know it is happening. And so these are, real concerns to be thinking about with that loss of empathy, which happens with face-to-face. But what you're talking about is something different, where I guess what we could look at is just the satisfaction numbers that you get from some of the programs like the CRT. Also, of course, in Ohio, they provided some different data that's out there. Utah has some early numbers, but they need to go a lot more deeply into the research that they've done to date because it's just only been a real start. But I think that's a different question is do individuals feel more satisfaction? Do they feel more relaxed? Now, in terms of the actual outcomes, this is where we do run into some difficulty, because if it is, for example, an online mediation, right, and they have a confidentiality agreement or they settle privately, how do we really have a way to find out what their mediated settlement agreement was? Because we might not. And so it's kind of tough to sort of gauge the outcomes. But I think in terms of satisfaction, we at least have some research, especially what the CRT has published.
Thank you.
I'm looking at the time and I'm realizing we've only got 1 minute left. So I want to just take that time to say thank you so much, Amy, for having this conversation. This was incredibly thought-provoking. A lot of people asked about your slides. I don't know if you'd be willing to share a PDF of them, but if you share them with
my
me.
pleasure. And
Yeah,
by the way, I just want to say thank you to Katie's point. That's really interesting that, or no, I guess it was Brian, that a friend was actually mediating asylum cases in the UK and said it was going really well. So again, we don't know whether the research study is completely accurate as well. That's really interesting. But
yeah, I will say I've seen some research that shows that the satisfaction numbers, and especially the empathy, as you say, is higher in in-person processes, but the preference numbers are off the charts for online, and it's purely due to convenience and cost savings.
Right.
So, you know, what are we willing to sacrifice on the altar of efficiency, I think is a key question.
Yep.
But Amy, please keep up the great work you're doing. Thank you for sharing it with us. I put a couple links in the chat. And if you're willing to share your slides, that's great. But I did record it, and I'll put the recording together and circulate it with everyone.
Happy to share it. And thank you guys for taking time with me. Thanks a lot. This has been super fun discussion, and it's so nice to see a lot of friendly faces. But nice to see you guys, even though we can't be in person. At least it's fun to see you online. So thank you.
Soon enough, we'll be in person. Okay, thank you so much, Amy. Have a great day, everyone. Have a wonderful holiday, and we'll reconvene early in January for our next Icodr member call and online mediators call. Thank you so much. All right.